Good afternoon, everyone, and welcome back to the Future of Europe. Today we are with Loudini Syrine, a student in first years of Masters in International and European Law, who will be sharing her insights on the balancing of judicial cooperation and protecting the fundamental rights.
Thank you for having me.
Can you tell us what is the central issue in the Brian case and why is it significant?
The central issue here revolves around whether a European arrest warrant issued by Romania against Prince Philip al Romani can be executed given allegation of systemic deficiencies in the Romanian judiciary system that may violate fundamental rights, particularly Article 47, the right to a fair trial. The legal basis for the European arrest warrant is found in Council Framework Decision 2002-584, which establishes the system of a mutual recognition of judicial decision in the EU. The principle of mutual recognition, enshrined in Article 82 of the TFEU, is a cornerstone of judicial cooperation. However, the court has ruled that mutual trust is not absolute and must be balanced against fundamental right considerations. To give a bit of context, the case involves Prince Philip of Romania. He was sentenced to almost 4 years in prison for corruption related to the illegal restitution and sale of nationalized royal properties. France and Malta refused to extradite him, arguing judicial independence concerns and poor prison conditions in Romania. What makes this case important is that it emphasizes the tension between, on one hand, mutual trust and mutual recognition and fundamental right in the EU. While the European arrest warrant ensures that criminals cannot evade justice by crossing the borders, this case shows that extradition is not automatic. Member states can refuse to comply if fundamental rights are at serious risks. And this is not the first time this issue has arisen, because in the LM case of 2018, Poland's judicial system independence was questioned due to controversial judicial reforms. The court ruled that EU member states must assess the risk of an unfair trial before extraditing a person to Poland, and this precedent is directly influenced and affect the Brian case.
Okay, so what were the key arguments made by the French and Maltese courts in refusing to execute the EAW?
Here, both Malta and France rejected the extradition, but for different reasons. In one hand, judicial independence. France focused on judicial independence. It found that one of the judges involved in the trial only taken oath as a prosecutor, and another judge oath was missing, record was missing. These irregularities were raising doubt about whether he had received a fair and impartial trial, violating Article 47 of the EU Charter. On the other hand, Malta focused more on detention conditions. It argued that extradition could expose Prince Philip to inhuman or degrading treatments, violating Article 4 of the Charter. The Maltese court relies on publicly available reports concerning indicating poor prison conditions, such as overcrowding or potential mistreatments. However, Malta did not request any further guarantees or assurances as required by EU law before rejecting an European arrest warrant. In the Doro Bentu case, the court ruled that poor prison conditions can justify refusing the European arrest warrant, but the executing state must seek updated guarantees from the issuing state before making final decisions, which was not the case here. So Malta's failure to do so raises questions and concerns about whether it fully complied with EU procedures.
So could you tell us how does the CJEU propose balancing mutual trust and the fundamental rights in such cases?
The court reaffirmed the principle of mutual trust. However, it also stressed that this trust, as I said, is not absolute. To refuse an European arrest warrant, a member state must provide specific, reliable, and objective evidence that the individual will face serious risk of human rights violations. The state must also request additional information or guarantees before from the issuing country before making a final decision. For example, if Malta requested more informations and guarantees on improved detention conditions, and Romania had provided them, Malta might have been required to extradite principal. This approach ensures that European arrest warrants are based on facts and not assumptions, preserving both fundamental rights and also judicial cooperation, which is important.
Thank you, Syrine. What does this case reveal about the broader implications for European judicial cooperation?
In my opinion, this case exposes weaknesses in mutual trust among EU member states. Some states, for instance, like Poland or Romania, maybe have been criticized multiple times for political interference in the judiciary, corruption, or even poor prison conditions. While other, for instance, France or Germany, have maybe more stronger legal safeguards for fair trial and human rights. These differences create tensions in the European arrest warrant system and shows that it still exists differences and not a complete uniformity among the member states. The EU may need stronger legal safeguards to ensure fair trials in all member states, for example, improving prison conditions, enhance cooperation mechanisms through maybe more dialogue between judicial authority that could help to resolve concerns without refusing necessarily extraditions. So, lastly, I would say that this case shows that judicial cooperation must take human rights into account, while also acknowledging the difficulty of maintaining trust in such a diverse legal system. Finding the right balance will shape the future of EU criminal justice.
So, thank you, Syrine, for participating in this program, and thank you for being with us in the future of Europe.